Good afternoon. Welcome to the World Championship round of the 1999 Jessup competition. This is the 40th anniversary this year, and it's been an incredible week of competition. As you know, the name of the case is the case concerning the cultural identity and intellectual property. It involves Bretoria and Pagonia. I would like to take a moment and introduce the oralists. The applicants have team members from the National Law College of India. The first is Sampna Kurjure. I know him. I'll try better with this one. The second oralist is Dipin Sumherwal. The respondents are from the University of Pretoria in South Africa. The first, Lawrence Mashava. The second oralist is Lungawe Matakala. Thank you all for coming this afternoon. Good luck to both teams.
The case before the court is the matter of the state of Pretoria versus the kingdom of Pagonia. The applicant and respondent teams are each allocated 45 minutes to present their respective pleadings.
Please be seated. The court is in session. The International Court of Justice sits today in Washington, D.C. to hear the case between the Republic of Bretoria and the Kingdom of Pagonia, submitted by special agreement pursuant to Article 40, Paragraph 3 of the Statute of the Court. Before I would give the floor to the distinguished agent and counsel of the two parties whose presence I acknowledge in the courtroom, I would like to make a technical remark. This case has been brought to the court by special agreement. Nevertheless, the two parties are being referred as the applicant and the respondent. Technically, a case that is brought by special agreement to this court does not distinguish between who is the applicant, who is the respondent, so that we will treat both parties on an equal basis without considering that anyone plays a particular role. I recognize the agent of the Republic of Bretoria. You have the floor.
Please, Your Excellencies, I am Sapna Khajuria, agent for the applicant, the Republic of
Excuse me,
Pretoria.
I did not want to confuse.
Yes, Your Excellency.
You have been pleading as if you were applicants and respondents, and you can continue to plead so.
Obliged, Your Excellencies.
Please.
I am the agent for the Republic of Pretoria, appearing before this Honorable Court in the case concerning cultural identity and intellectual property. Your Excellencies, the Republic of Pretoria would be making 4 primary submissions before this Honorable Court, which are, firstly, that the acts taken by the Kingdom of Pagonia requiring a minimum local content in audiovisual programming, as well as with respect to periodicals, are illegal under international law because they violate the customary norm of national treatment. The second submission would be that the forced divestiture of ownership in the cultural sector, as well as the termination of valid television contracts, constitute illegal expropriation under international law. The third submission would be that the level of protection being afforded to copyright owners by the Kingdom of Pagonia is insufficient under international law, because of which Pretorian nationals have suffered damages. And the last submission before this Honorable Court would be that for these damages caused by the Kingdom of Pagonia, it is obliged to make reparations to Pretorian nationals. Your Excellencies, I shall be taking 20 minutes of this court's time and would be addressing this court on the issues of national treatment and cultural identity protection with respect to radio, television, and periodicals, while my co-agent, Mr. Dipin Sabharwal, would be addressing this court for 22 minutes on the issues of the legality of expropriation and copyright protection.
Thank you, distinguished agent. For my own benefit, as I have just arrived from The Hague and have not had the pleasure of following the semifinals or the preceding aspects of the competition, could you briefly tell me, as this case has been brought by a special agreement and under Article 40 of the statute, and Article 40 has only 2 requirements. One, the identification of the parties. We have dealt with that before. And the other, of course, the identification of the legal dispute. And then Article 2 of the special agreement requests this court to decide the case on the basis of the rules and principles of general international law, as well as any applicable treaties. As to the first question, I would ask you simply to restate what, in your view, is the dispute that has been brought to this court. And as to the second, I would point out that you both have agreed in the special agreement that the Kingdom of Pagonia is not a party to any of the relevant treaties discussed in the compromise. The only treaty which you both acknowledge, both of you are parties, is the Vienna Convention on the Law of Treaties.
Yes,
But if treaties are not binding on one of the parties, as agreed by you both, at some point I would appreciate if you explain to me what is the relevance of the reference in the special agreement to you both being parties to the Vienna Convention on the Law of Treaties. Thank you.
Yes, Your Excellencies. Your Excellencies, if I understood Your Excellencies' first question, it was, what is the dispute in the instant case?
Yes.
Yes, Your Excellency. Your Excellencies, I would answer the 2 questions one by one. Firstly, with reference to the first question, the dispute in the instant case is whether Pagonia, the Kingdom of Pagonia, had any right to provide for a minimum local content requirement, thereby violating, as we allege, national treatment. Secondly, whether the level of protection of copyright in Pagonia was adequate. And thirdly, whether any expropriation was carried out by Pagonia. Your Excellencies, with reference to the second question, Your Excellencies, it is given in the compromise that both parties are signatories to the Vienna Convention on the Law of Treaties. Your Excellencies, Article 38 of the same convention provides that if a particular norm in a treaty or a treaty has reached the level of a customary principle of international law, it applies to all parties, whether or not they are signatories. Your Excellencies, the relevance of the presence of the fact that both parties are signatories to the Vienna Convention is the following. Pagonia is not a signatory to the General Agreement on Tariffs and Trade, which I shall be referring to as the GATT hereinafter. Yes, Your Excellencies, however, it would be the submission for the Republic of Bretoria that the principle of national treatment, as given in Article 3 of the GATT, has reached the level of a customary norm of international law. Therefore, because of Article 38 of the Vienna Convention, as well as this Honorable Court's dictum in the North Sea Continental Shelf cases, it would bind the Kingdom of Pagonia. Your Excellencies, if that answers Your Excellencies' question sufficiently, may I proceed with my first submission?
You may proceed.
Much obliged, Your Excellencies. Your Excellencies, the first submission for the Republic of Pretoria is that national treatment, as defined by Article 3 of the GATT, constitutes a customary norm of international law, and the Kingdom of Pagonia, by requiring a minimum local content, has violated this very customary norm. Your Excellencies, I shall be addressing this at two levels. Firstly, that national treatment is a customary norm, and secondly, that cultural identity or cultural exception is not a valid exception. Your Excellencies, as the agent pointed out, in the North Sea Continental Shelf cases in 1969, this very honorable court held that if a treaty or a norm in a treaty can give rise to a customary principle of international law if the following conditions are met. Firstly, if the treaty is norm-creating in nature. Secondly, if it has widespread relevance or practice in international law. And thirdly, if the requirements for the formation of custom, that is, state practice, supported by opinio juris, are met. Your Excellencies, it would be the submission for the Republic of Bretoria that all these conditions are met, and therefore, Article 3 of the GATT is a customary norm of international law. Your Excellencies?
If
Yes,
I
Your
may
Excellency.
interrupt, Judge Wilner would like to pose a question.
Indeed, Your Excellency.
Thank you. One of the points that you've just made is that the GATT, that in order to be within the scope of the type of treaty that gives rise to custom, it has to be general, widespread, and generally applicable. Well, GATT is a treaty, an agreement on certain trade issues. It's an agreement really on the movement of goods. For much of its history, it was an agreement on the movement of manufactured goods. How can one say that an agreement of sorts, as it was before, on this important but limited area can be said to have general application?
Your Excellencies, the following answers. Firstly, Your Excellencies, in the North Sea Continental Shelf cases itself, this Honorable Court held that not universal but general acceptance or following of a treaty is required. Secondly, Your Excellencies, despite the fact that the GATT deals with trade, it would be our submission that trade is a very important aspect of international law. Thirdly, Your Excellencies, the fact that more than 95% of the world trade is carried out on the basis of GATT. Your Excellencies, in the preamble of the GATT, it is made clear that the aim of the GATT is to eliminate discrimination in international trade. Your Excellencies, it is our submission that the GATT attempts to do so by means of putting forth a code of conduct that governs international trade. Your Excellencies, if I may clarify, our submission is not that the entire GATT is a customary norm of international law. It would be the submission for the Republic of Bretoria that the core principles of the GATT, for instance, in this case, the national treatment principle, because of its wide relevance in the GATT, as well as its being followed in several free trade, commerce, and navigation treaties, in bilateral investment treaties, etc., has led to its becoming a norm of customary international law.
I may interrupt the agent.
Yes, yes.
Judge Richstone would like to, at this point, also ask a question that may help clarify the question also asked by Judge Wilner.
Certainly.
Josh.
Yes, I would like to ask if you could suggest to me any state not party to the GATT that, in your opinion, accords national treatment outside of being a member of the party of the treaty. Has any non-treaty state accorded national treatment in terms of goods and services in an economic arrangement, in an economic context?
Your Excellencies, for instance, Albania, when it was not a party to the GATT, was according national treatment to all the countries that were dealing with it with respect to trade relations. Your Excellencies, it is also our submission that recently Taiwan has agreed to provide a sort of national treatment, though it has not agreed to sign the GATT. Your Excellency.
Is Taiwan not a member of the Berne Convention?
Your Excellencies, I do believe that Taiwan is a member of the Berne Convention, yes.
In that case, they would be providing national treatment.
Your
in terms of
Excellency,
intellectual property, would they not?
Your Excellencies, yes, with respect to intellectual property, however, not with respect to its other trade relations. Much obliged, Your Excellencies. Your Excellencies, it is further submitted that the GATT is a norm-creating treaty which lays down a the rules for a multilateral trading system in international law. Your Excellencies, several publicists have also supported the proposition that the GATT is a norm-creating treaty and would apply to non-parties as well. For instance, Professor Shaw and Professor Stark. Your Excellencies, further, even after the GATT, the principle of national treatment has been incorporated in more than 500 bilateral investment treaties, in 48 free trade, commerce, and navigation treaties entered into by the United States, in all the commercial treaties entered into by the United Kingdom. Yes, Your Excellency.
Judge Richstone would like to ask another question, please.
Agent, I'd like to ask you, is it not the case that a number of publicists have already said that it is contrary to a provision of a treaty achieving a norm of customary law, the fact that in the treaty you have the existence of reservations, you have the existence of exceptions, you have a number of other provisions which would cut down on the generality of that norm. And I turn to you in terms of GATT, there were grandfathering clauses that were recent. Do you not think that the existence of the grandfathering provisions, of exceptions, and other reservations in GATT defeat your argument? And if so, why not?
Yes, Your Excellencies, if I may answer the question by giving an analogy in international law. Your Excellencies, there exists in international law a principle of non-use of force, which is also present in Article 2, Clause 4 of the Charter of the United Nations, which has already been accepted as being a customary norm of international law. Your Excellencies, there also exists in international law a customary principle of the right to self-defense present in Article 51. Your Excellencies, it is our submission that the mere fact that there exists an exception or a contrary provision or an escape clause for a particular customary norm in international law does not in any way mean that the particular clause or the particular custom has ceased to exist. Further, Your Excellencies,
If I may ask myself a question, you give the example of the prohibition of the threat or use of force. That, of course, is a norm of jus cogens.
Yes.
Are you arguing that Article 3 of the GATT embodies a norm of jus cogens?
Certainly not, Your Excellencies. It was merely a kind of an analogy being drawn. Further, Your Excellencies, it is our submission that with respect to the GATT, most of the grandfathering clauses are because of the fact that the GATT was in 1947 when most countries were reluctant to give up their independence or so-called sovereignty with respect to trade. Further, Your Excellencies, most of the exceptions that are present in the GATT are very difficult to apply, and there are very strict provisions for opting out or even waivers within the GATT. Therefore, Your Excellencies, it is our submission that the core principles of the GATT, for instance, the national treatment, have reached the status of customary international law.
Judge Wilner would like to ask a question.
Yes.
Well, just a short follow-up. Would you then be saying that there is that national treatment, the standard of national treatment, is a standard of international law with respect to those areas in which the GATT is effective, namely the the movement of goods across national boundaries. And that as to other areas of international
Yes, Your Excellency.
relationships, that some other rule may, or that in fact there is no rule with respect to how states may treat foreigners.
Your Excellencies, there does exist a principle of national treatment with respect to the way a country treats its aliens under its national laws as well. Therefore, Your Excellencies, this principle applies not only to world trading law, but also to the treatment of aliens by an individual state. Your Excellencies, would that be a sufficient answer to Your Excellency's question?
That is the national treatment is the rule that applies, and that is the only standard that applies with respect to, it is the general standard that applies with respect to the treatment of aliens.
Your Excellencies, it is one of the rules in international law that applies to the treatment of aliens by a sovereign nation, yes. Your Excellencies, may I proceed with my submission?
I see you have only 5 minutes left for your own presentation. Perhaps you could tell us now, in the way you have described, you were going to present your argument. How do you see the opinion juris aspect of this side of the argument?
Your Excellencies, the opinion juris of the GATT or with respect to Pagonia?
No, from your own perspective, in making Article 3 of the GATT a norm of customary international law.
Yes, Your Excellencies. Your Excellencies, the opinion juris, that is the feeling of the countries that have signed the GATT, that they are obliged under international law to provide national treatment, can be clearly seen from the fact that when these countries, in their bilateral trading relations, for instance, the United States in its NAFTA, and the United States with its FCN treaties with respect to other countries, and several other third world countries have entered into FCN treaties and particularly preferred the national treatment clause within the treaties, clearly goes on to show that these countries believe that the norm of national treatment has become binding upon them. Your Excellencies, further, because more than 95% of international trade today is governed by this very principle. Thirdly, Your Excellencies, countries referring specifically to Pagonia. As is clear from paragraph 27 of the compromise, Pagonia wishes to join a regional association of trading states, which is a free trade area. This, Your Excellencies, plus the fact that Pagonia has recently undergone liberalization, clearly goes on to show that Pagonia too does believe itself to be bound by free trade. Your Excellencies, as I have only 2 minutes left, may I move on to the issue of cultural identity? Much obliged, Your Excellencies. Your Excellencies, firstly, it may be submitted that, as was held by this Honorable Court in the asylum case, the burden to prove the existence of a custom is upon the party that purports to accept it. Your Excellencies, therefore, the burden to establish that there is a cultural identity exception within customary international law is upon the Kingdom of Pagonia. All that the Republic of Bretoria in this case has to do is to establish that there is inconsistency in state practice to that effect, which agent would establish to do now. Your Excellencies, firstly, at the Uruguay round of negotiations on the General Agreement on Trade and Services, a proposal led by the European Union to exempt cultural items from national treatment reached a discord till the very end. Secondly, Your Excellencies, the recent European Union Television Without Frontiers Directive which wanted quotas for television and radio programs, met with dissents from as many as 3 countries of the European Union, which were Belgium, Netherlands, and Portugal. Your Excellencies, the United States-Canada Free Trade Agreement has a retaliatory clause. Your Excellencies, further, in the certain measures concerning periodicals case. Yes, Your Excellency.
Justice Richstone has one question, please. We will waive the time to allow him to ask the question and you to respond.
I'm not sure I follow you, Agent, on this. You cite all these instances. Don't all these instances prove or suggest that there is state practice? You've referred to GATT and a number of countries, a great number of countries acceding to the GATT, to the World Trade Organization Agreement. That may be a instance of state practice. On the other hand, the instances that you're raising right now, wouldn't they prove that there is some sense among countries of a cultural, if you want to call it exception, or a need to protect cultural industries?
Your Excellencies, it would be our submission that the very fact that these countries are themselves unable to get a consent or a consensus with respect to a cultural identity protection. Secondly, Your Excellencies, that even when, for instance, in the United States-Canada Free Trade Agreement, there is a kind of a provision for cultural identity protection, there is a retaliatory measure which is provided. Your Excellencies, our simple submission is that there exists no consistency in state practice and no opinio juris, because these countries do not feel themselves to be obliged to provide such an exception, clearly goes on to show that because the two elements for the formation of custom are not fulfilled, there exists no norm for the protection of cultural identity as such, as an exception to national treatment. Your Excellencies, this was also dealt with in the certain measures concerning periodicals case by the WTO dispute settlement body, which decided the case on the 30th of June 2 years ago. Yes, Your Excellency.
Thank you, Agent. We have gone over your time. We will deduct from the remaining time available to your team the few minutes that the bailiff here has, not 1 minute, it was not
Thank
much.
you very much for your attention, Your Excellency.
I call on the distinguished counsel for the Republic of Bretoria.
If it may please, Your Excellencies, I am Dipen Sabharwal, agent for the applicant, the Republic of Bretoria, appearing before this honorable court in the case concerning cultural identity and intellectual property. As the co-agent for the Republic of Bretoria, I shall be making 3 submissions before this honorable court. The first submission would be that the divestiture of ownership interests and the termination of valid contracts by the Kingdom of Pagonia constitutes unlawful expropriation in international law. The second submission would be that the standard of copyright protection afforded by the Kingdom of Pagonia is insufficient in international law. And the final submission would be that since the Kingdom of Pagonia has breached its international engagements, there exists an obligation upon its part to make reparations for the same. With your kind permission, Your Excellency, I would beg to elucidate on these submissions. Much obliged. Your Excellencies, the first submission before this honorable court would be that the forced divestiture of ownership interests in the Pagonian cultural industry and the termination of valid contracts constitutes expropriation, which is unlawful in international law. Your Excellencies, expropriation.
Judge Wilner would like to ask a question. Judge Wilner, please.
I think we need to ask this at the very beginning of your discussion. Are you saying that expropriation is invalid under international law? Expropriation as a general rule is invalid under international law?
No, Your Excellencies, it is our submission.
Before you answer, co-agent, would you please tell the court how long you intend to speak so that we can keep the time
Your
element
Excellencies,
under control?
I would be addressing this honorable court for 22 minutes on the point. Your Excellencies, the Republic of Bretoria accepts that the taking of property in international law by a state is recognized and is permissible and legitimate, provided that certain essential conditions are complied with. Your Excellencies, those conditions are, firstly, the existence of a valid public purpose, secondly, non-discrimination, and thirdly, the payment of prompt, adequate, and effective compensation. It is the contention of the Republic of Bretoria that these conditions have not been complied with in the instant case, and therefore the expropriatory action is unlawful in the instant case. Your Excellencies, I shall now be endeavoring to establish that these 3 contentions, these 3 propositions are satisfied independently, and therefore the expropriation is unlawful. Your Excellencies, as regarding the discriminatory attitude of the Kingdom of Pagonia, Your Excellencies, as pointed out by this very honorable court.
I take it that you are not questioning the public purpose aspect. You mentioned three aspects, and you are already going into the discriminatory aspect. So do you concede that the actions taken by the Kingdom of Pagonia did serve a public purpose?
No, Your Excellencies, I would be addressing this court on the public purpose issue as well, if I would start with that, in fact. Your Excellencies, it is our submission that civil law number 51, which allegedly tries to protect Pagonian cultural identity, does not fulfill the criterion of public purpose. Your Excellencies, in the instant case, civil law number 51 has the avowed intention of protecting Pagonian culture. However, Your Excellencies, what civil law number 51 actually does is that it transfers ownership from non-Pagonian citizens into the hands of Pagonian citizens. If the intention and the public purpose of the Kingdom of Pagonia was to ensure that Pagonian materials and Pagonian literature was promoted, Your Excellencies, there was no need to transfer ownership from non-Pagonians to Pagonians. The reason for this is, Your Excellencies, is that the compromise clearly indicates that the Pagonians themselves in Pagonia were predominantly selling foreign literature and media. Therefore, Your Excellencies, there exists no public purpose in the instant case.
Judge Richstone, please.
Agent, a number of countries have enacted laws in relation to broadcasting in which they provide that the majority interests in the broadcasting sector would be held by nationals of the country. Are you suggesting that that legislation is without a public purpose?
Your Excellencies, it is our submission that, as pointed out by this honorable court in the Electronica Secura case in 1989, the tests of expropriation along with public purpose have to be necessity and proportionality. This court has to ask that whether the steps undertaken to protect its cultural identity, whether they were necessary and proportionate, and the means and the ends justify themselves. Your Excellencies, we do not deny that cultural identity is indeed a valid public purpose. However, Your Excellencies, in the instant case, the public purpose has been distorted, and civil law number 51 is furthering the private financial interests of certain individuals rather than protecting Pagonian cultural identity. Your Excellencies, that is our submission.
Justice Wilner would like to pose a question, please.
Just to follow this up, couldn't the law have two purposes? And it would appear to me that while it's true that it would result in the transfer of property to nationals of Pagonia, it could just as well at the same time put these means of cultural expression in the hands of people who speak the language, who know the culture of the particular country.
Yes, Your Excellencies, the answers to your questions. Firstly, Your Excellencies, as regarding whether there could not exist two purposes, Your Excellencies, there could exist very well two purposes. However, both have to be public purposes, Your Excellency. Cultural identity is certainly a public purpose, but serving the private financial interests of publishers and Pagonian owners is certainly not a public purpose. On the question whether Pagonians speaking the same Pagonian language would be in a better position to protect Pagonian culture, Your Excellencies, the compromise clearly indicates that there is vast proliferation of foreign media literature in Pagonia. Your Excellencies, this proliferation is being brought about by Pagonians themselves, Your Excellencies, as the compromise clearly indicates that most Pagonians were selling foreign materials, videos, as well as other media. Your Excellencies, therefore, by transferring the ownership to Pagonians would not bring about a protection of Pagonian cultural identity. That would be a contention, and these measures are unproportionate in the contention of Republic of Pretoria. May I proceed, Your Excellencies?
Judge Richstone.
Well, in fact, you're asking us to second-guess the legislature, aren't you?
Yes, Your Excellency.
You're asking us to second-guess the legislature in a matter of cultural identity. Do you have any precedents for any decisions of this court or international law in which a tribunal has second-guessed the democratically elected decisions of the legislature?
Your Excellencies, in the British Petroleum Arbitral Award of 1979, the arbitral award went into the question of public purpose and whether the Libyan acquisitions of British petroleum oil rigs indeed was constitutive of public purpose. and the arbitral tribunal came to the conclusion that the takings were motivated not by reasons of socialism and redistribution of economic resources, but instead motivated by the actions of retaliatory nature against Britain for acting in a particular manner in the Persian Gulf. And Your Excellencies, such expropriation was held to be unlawful. Your Excellencies, there does exist judicial precedent on the point. If I may proceed, Your Excellencies. Much obliged.
Please.
Your Excellencies, it would be our submission that the Civil Law number 51, Article 2, Paragraph C, which mandates that all non-Pagonian citizens divest themselves of ownership within a period of 90 days, is discriminatory in attitude and therefore unlawful under international law. Your Excellencies, as pointed out by the International Court of Justice in 1989 in the Electronica Secula case, non-discrimination is an essential requirement that needs to be satisfied for an expropriation to be lawful. In the instant case, Civil Law number 51, by discriminating against Pagonians and non-Pagonians, is creating a differential standard which is discriminatory and therefore contrary to international law. Your Excellencies, if I've satisfied you on the point, I will be moving on to the question of compensation.
Please.
Much obliged. Your Excellencies, it would be our further submission that the standard of compensation in international law is that of prompt, adequate, and effective compensation, and this compensation standard has not been fulfilled by the payment of book value to the Praetorian investors by the Kingdom of Pagonia. Your Excellencies, the constitutions of 62 countries across the world mandate full compensation as a criteria for compensation in the cases of expropriation. More than 200 bilateral investment treaties concluded amongst 91 nations specify that full compensation has to be paid in the cases of expropriation. Your Excellencies,
Justice Wilner would like to ask a question, but I would ask you briefly if the standard was one of full compensation, why the reference is to adequate compensation and not straightforwardly to full compensation? Justice Wilner, please.
My question really lies with respect to the issue of the impact of provisions of a bilateral contractual relationship that states enter into with each other. There's nothing that, and this is my view, and I'd like you to see whether this accords with your understanding. There's nothing in a particular bilateral treaty that commits a state to a general acceptance of a particular rule that that state may, for various reasons, including economic duress, agree to in that particular situation.
Your Excellencies, dealing with the Honorable President's question first. Your Excellencies, as regarding the formulation of the compensation standard, whether full compensation or adequate compensation, Your Excellencies, I was referring to adequate as a part of the Hull formula as articulated by Secretary of State Cordell Hull in his 1938 note to the Mexican government.
But you would, of course, be aware that there is also a reference to appropriate compensation in instruments like the Economic Charter, Charter of Economic Rights and Duties of States. So would you elaborate also in the light of this other standard?
Your Excellencies, the term appropriate compensation finds its genesis in international law of expropriation in the 1962 Declaration on the Permanent Sovereignty over Natural Resources, in which the compensation standard was defined as appropriate compensation in accordance with international law. Your Excellencies, as pointed out by Mr. Stephen Schwebel, who was at that time the legal advisor to the United States State Department and now currently the President of this Honorable Court, that the United States and other developed countries voted for this resolution on the explicit understanding that appropriate compensation in accordance with international law would imply prompt, adequate, and effective compensation as understood by the Hull formula. That was the understanding of the developed countries, and that was the reason why this resolution enjoyed the support of all the nations and has therefore acquired the status of opinio juris communis. Later resolutions like Charter of Economic Rights and Duties and the new International Economic Order, which use the phrase appropriate compensation and not in accordance with international law, did not find the support of the developed countries, Your Excellencies, and therefore cannot be indicative of the customary law on expropriation.
So you are arguing by citing my predecessor as president of this court, Justice Schwebel, in his capacity of legal advisor to the State Department, that unless developed states would agree to a norm as one of customary law, there could be no customary law norms. Is that your position in general, or only in this particular issue of compensation?
Your Excellencies, if I may rely upon the dictum of this court in the North Sea continental shelf cases, it was the position of this very honorable court that for a customary norm of international law to change, the content of a customary norm cannot change in the face of stiff and extensive resistance from those parties who have an interest in the matter. Your Excellencies, it is our submission that the customary norm which existed in 1962 and prior to that was that of prompt, adequate and effective compensation. For this norm to change, there must be overwhelming consensus in international relations, as pointed out in the North Sea cases. Your Excellencies, the developed countries like the United States, the United Kingdom, Canada, Belgium, France, all these countries, Your Excellencies, have a vital interest in the matter, since more than 80% of foreign direct investment belongs to those countries. Therefore, Your Excellencies, without the consent of these parties who are directly affected by the international law on the standard of compensation, the customary content of expropriation standards in international law cannot be deemed to be changed as per the North Sea cases, Your Excellencies. If I have answered your question. Your Excellencies, if I may go back to His Excellency's question on the significance of bilateral investment treaties. Your Excellencies, again, the North Sea continental shelf cases, bilateral investment treaties, or for that matter, any bilateral treaty, cannot be constitutive of customary law by itself. However, widespread and consistent state practice, as evidenced by bilateral investment treaties, would be indicative of state practice giving rise to customary international law. Your Excellencies, it is our contention that 200 bilateral investment treaties conducted between 91 nations would be consistent, widespread and general practice, and therefore would lead to the crystallization of a norm of customary international law. Your Excellencies, due to paucity of time, if I may address this court on the issue of copyright. Much obliged. Your Excellencies, it is our submission that the Kingdom of Pagonia does not afford sufficient protection to copyright owners, and this constitutes a breach of international standards. Your Excellencies, the Article 27...
would you please be more precise? You say a breach of international standards or a breach of international customary law?
Your Excellencies, it is our submission that there exist certain minimum standards of copyright protection in customary international law. Therefore, it is a breach of international standards as evidenced and present in international customary law. Much obliged, Your Excellencies. Your Excellencies...
Judge Wilner?
Does your contention mean that countries whose basic economic system does not permit the ownership of private property, or whose system does not reward in a pecuniary fashion, but rather in a moral and spiritual fashion, the originality of authors, such countries do no longer have the sovereign right to choose the system that is used, but must be submitted to the copyright system, which has been aggressively pushed by certain countries.
Your Excellencies, it is the position of the Republic of Bretoria that irrespective of political or economic ideology, every state is obliged to protect human rights. And it is our contention that copyright, being a human right enshrined in Article 27, paragraph 2 of the Universal Declaration of Human Rights, is a human right which needs to be protected by the Kingdom of Pagonia. If I may quote Article 27, Your Excellencies, it states that everyone has a right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he or she is the author. Therefore, Your Excellencies, copyright is a human right and therefore has to be protected.
Copyright, as we know it, is really fundamentally a pecuniary, a financial right. The Universal Declaration talks about protection in general, protection of the name, protection of the connection with the author. Couldn't that have been what they meant?
Your Excellencies, the Universal Declaration of Human Rights specifies the moral and the material interests. Your Excellencies, it would be our submission that material interests would involve compensatory remedies as well as awarding of a preventive injunctory relief to avoid duplication. Moreover, Your Excellencies, Article 15, Paragraph 1, Clause C of the International Covenant of Economic, Social and Cultural Rights also reiterates the precise formulation as contained in Article 27 of the UDHR, thereby reiterating copyright as being a human right whose moral as well as material interests need to be protected.
Judge Richstone, please.
I have some difficulties in your statement, Agent. In many legal systems, copyright is a statutory right. The copyright apart from statute does not exist. How does your assertion square with that legal fact in many legal systems of which one may be aware of? The other question I have to you is if you're taking this position of copyright, how do you square that with the fact that in many copyright statutes you have existence of compulsory licenses, you have the existence of exceptions, you have the existence of collective administration? How can your statement be squared with that fact as well?
Your Excellencies, it is our submission that copyright is afforded statutory protection in more than 120 countries of the world. Countries belonging to wide and disparate economic situations such as China, India, Mexico, Chile, Argentina, United States, Indonesia, Thailand. Your Excellencies, despite economic and political ideologies, more than 120 countries belong to various economic and political systems and geographical locations do indeed protect copyright, Your Excellencies. Your Excellencies, as regarding the procedural requirements of copyright protection and the disparities that exist across the world, it is our submission that procedural requirements are not, it is not our contention that procedural requirements would be part of customary standards of copyright protection. It is our submission that certain minimum standards, Your Excellencies, such as provision of compensatory relief, civil remedies, awarding of preventive injunctory reliefs, and such common minimum standards which can be culled out from the various international treaty regimes such as the Berne Convention, the Rome Convention, the Paris Convention, as well as the TRIPS Agreement, Your Excellencies, would give rise to certain minimum standards of copyright protection which are universal and absolute in nature.
I would thank the co-agent. We exceeded slightly his time, but it was necessary to have your full answer. I would call on the counsel if there is some time left. Do we have some minutes left for the third oralist?
They want 1 minute and 45 seconds.
So they have exhausted their time now.
Yeah, for the rebuttal, they have the time.
There is a minute and a half left. Probably you may use it yourself, or you may then
Your Excellencies, it is my understanding that we have reserved 3 minutes for rebuttal and will be utilizing that time after the contentions of the Kingdom of Pagonia.
Fine. We will use this minute and a half for rebuttal time. I thank the co-agents of the Republic of Bretoria and would now call on the agent and co-agent of the Kingdom of Pagonia. You have the floor, sir.
Good afternoon, Your Excellencies. My name is Lawrence Mashaba. Appearing together with me as co-agent on behalf of the respondent, the Kingdom of Pagonia, is Longue Matakala. We have divided the issues in such a manner that I will deal with the issues of expropriation and national treatment for 23 minutes. Thereafter, my co-agent will deal with the issues of intellectual property for 20 minutes, and we reserved 2 minutes for sir rebuttal. With the permission of your excellencies, I will proceed to deal with the issues that I will tackle. In the compromise, the respondent asks this court to declare that the acts taken by the Kingdom of Pagonia in order to protect its cultural identity are lawful under international law, and consequently no duty to make compensation arises. I will submit 4 submissions in support of this particular prayer. The first will be that the expropriations of the cultural sector industries in Pagonia taken pursuant to Civil Law number 51 are lawful under international law. Secondly, I will contend that the rule of national treatment has not become a rule of customary international law. Thirdly, if such a rule has become a rule of customary international law, there is a valid exception allowed to be taken in order to protect cultural identity. And finally, I will contend there is a result of there being no rule of international law which has been breached, no duty to pay compensation arises on the part of the respondent state. If Your Excellencies will give me permission, I will proceed to the substantive part of my argument. Under international law, a state is allowed to expropriate property. Pursuant to that, the Kingdom of Pagonia passed Civil Law number 51 to expropriate cultural sector industries. However, such a rule has certain limitations. There are requirements which must be met in order for such an expropriation to be considered as lawful under international law. Applicants have already alluded to those requirements. The first two we contend are the requirements. However, in regard to the third one they mentioned, that of compensation, we contend it is not a requirement for the lawfulness of an expropriation, but merely a consequence which follows from the expropriation. I will therefore deal with the first two requirements, that of public purpose and non-discrimination, and thereafter I will deal with the legal consequence and show that that legal consequence has been complied with as well. With regard to public purpose, a state is given a wide discretion and a wide and extensive discretion in determining what its public purpose is. This rule was stated by the Amico Arbitration Tribunal arising out of the Iran-US Claims Tribunal, where they stated that a state has a wide and extensive discretion to determine what is in its public good. The Kingdom of Pagonia has determined that to protect its cultural identity is in its public good. It has decided that the measures which are best able to carry out this public purpose is by expropriating property in the hands of foreigners owned in cultural sector industries.
Justice Richstone has a question, please. Justice Richstone.
Agent, what do you say to the argument of Agent for Bretoria that there is no public purpose because the effect of the measure is simply transferring property from one set of property owners to another, and it has nothing to do with the stated purpose of the measure?
We contend, Your Excellencies, that it was a necessity that those cultural sector industry shares be taken to Pagonians. Pagonians are the ones who know their culture. They are the ones who are in a position to express their culture. Even so, the Ministry of Culture, before selling those particular shares to the Pagonians who were to take care of them, made them make commitments to the protection of Pagonian culture in carrying out those particular businesses.
Agent, if the goal was culture, why wouldn't you just enact content regulations as you did with the periodical?
Your Excellency, in fact, the Civil Law number 51 and expropriations came before the contents. The government, again, is given a wide discretion here. We realized that those measures were not as effective and they needed to be supplemented, and they derived the authority, the minimum content rules also derive the authority from the Civil Law number 51, which is in question here, Your Excellencies. Therefore, given our wide discretion and the margin of appreciation which is operative has been operative in the European Court of Human Rights system, especially in the case of Lithgow versus the United Kingdom, we have decided that the measures we have taken are the ones which will best achieve the public purpose which we want to achieve. In other words, to protect our cultural identity.
Could I ask the agent to elaborate a little further on his concept of cultural identity? We understand that you are protecting cultural identity, but what does it mean in more concrete terms, cultural identity for you, other than the aspect of transferring ownership from foreigners to nationals?
Your Excellency, there is no legal definition to the term cultural identity. I'm not sure if I understand your question exactly. Do you want me to explain the concept of cultural identity?
You are arguing that there is something here to be protected called cultural identity, but could you elaborate what that concept means in concrete terms for you?
Yes, Your Excellency. There is no legal definition as to what exactly cultural identity is. However, anthropologists agree that there are 4 different types of culture, given the definition to culture is. In those 4, it includes artistic works, expression of culture through artistic works, including works of music, as in contained in videotapes, in television programs, and in other art programs. Therefore, those products, the products which the cultural sector industries were in charge of distributing, are cultural products, are products which reflect a nation's culture, which are used to exhibit culture. And therefore, we have decided that the Pagonians, if they are in charge of cultural sector industries, are in a position where they'll be able to use the medium, in other words, television or broadcasting, etc., in order to promote and decimate their own culture within their own particular state.
Once again, Agent, I must come back to it. As I see in the compromis, the content regulations were promulgated after the Civil Law 51, and it seems to me that if you go from a position of divestiture of majority interest without any guarantee of content in one set of regulations to another set which deals with content, isn't that more closely related to the goal that you just mentioned right now? You focused on cultural products. You didn't focus on cultural ownership. So I do not see how cultural ownership equals cultural and more cultural products, and I think that is the causal relationship that is key here.
Your Excellency, I emphasize again, a state in international law is given a wide discretion in determining best how to achieve what it wants to achieve. In this particular case, we contend that if we give to Pagonian nationals the chance to own the industries which are responsible for the expression of these cultural products, which produce these cultural products, they will be in the best position to expose and to disseminate their own culture, and therefore the cultural purpose which we purport exists does indeed exist, Your Excellencies.
But how would then you equate the achievement of this purpose? You seem to be narrowing down to the promotion of your own cultural values. If what is involved here is the production by Pagonian nationals of foreign cultural products.
Your Excellency, again, I mentioned the commitments which those who got their interests, they made a commitment. There is no evidence in the facts that those who did get the expropriated shares are the ones who were responsible prior to the passing of Civil Law number 51 for the decimation of foreign material. Those who were given those particular shares were made to make a commitment to the government of Pagonia that they will help and they make themselves committed to the promotion of Pagonian cultural identity. So as my co-agents here mentioned, Your Excellencies, there exists proportionality between the measures which were taken and the objective which is sought to be achieved. If Your Excellencies have no further question on the issue of public purpose, I will now move on to the issue of non-discrimination. Again, Your Excellency, we rely on the decision of the Amako case in the Iran-US Claims Tribunal. They said there that if there is a public purpose, then from that it must be taken that there exists an objective justification for the particular discrimination. However, it is not this prohibited discrimination. The distinction we drew, Civil Law number 51, drew between foreigners as a class on the one hand and Pagonians as a class on the other. There is an objective justification to the drawing of such a distinction. Therefore, the second requirement, that of non-discrimination, has been met in this particular case, and consequently the court must find that the two requirements set out under international law for the lawfulness of an expropriation have been met in this particular case. If Your Excellencies have no further question on the issue of non-discrimination, I will move on to deal with the issue of compensation. Arising again out of the Iran-US Claims Tribunal, the American International Group case stated that to pay compensation is not a requirement for the lawfulness of an expropriation, but merely a lawful consequence of the expropriating act. Therefore, if the court finds that the compensation required by international law has not been paid, the court cannot find that there has been an illegal expropriation. What would be required is to pay compensation, the difference between the compensation which was paid and the amount which the applicants allege has not in fact been paid.
Could you, I see you argue a great deal on the basis of decisions of an arbitral tribunal set up to deal with specific claims between two states, the United States and Iran. Could you cite other authorities in support of your position?
Your Excellency, I cannot. However, the Article 38(1)(d) of this court statutes allows it to look at decisions of international arbitral tribunals in deducing the principles of law. With respect to the Iran-US Claims Tribunal established in terms of the Treaty of Amity, there was in the first place to be applied the Treaty of Amity, and in the second place, customary international law. And we contend that in this particular case we've cited, the court stated that a general principle of international law, that even in case of a lawful nationalization, the former owner is normally entitled to compensation.
Yes, Judge Wilner would like to ask a question, but I would remind you that even under the statute of our court, a decision of this court is only binding on the parties to the case. Judge Wilner.
Well, I'd like to continue with that. The president of the court mentioned the fact that you were relying on a case in a particular in the context of a particular agreement between two states, a contract between two states. Admittedly, international law is to be used there. But can you then, on the basis of one case in the, or one decision in the this bilateral tribunal, arbitration tribunal, can you on that basis tell us that a particular very basic rule exists, or in fact has there been such a rule in existence, such a theory in existence for quite a long time?
Your Excellency, I draw your attention to the authority we cite in footnote 1 of our memorial, Pelon Par, taking of property in the practice of the Iran-United States Claims Tribunal. In that particular article, he reviewed decisions of the Iran-US Claims Tribunal, and he came to the conclusion that in the cases which the arbitral tribunals had to deal with the claims, where they were addressing the issues of international law, they came to the conclusion that compensation in all those cases was not a requirement, but merely a legal consequence which followed through the expropriation.
Why did they come to that conclusion? Does the author of the article tell us why they came to that conclusion?
Your Excellency, in my understanding of what he says in the article, it is that they were applying rules of international law, customary international law, not merely the rules of treaty, Your Excellency. Because in some cases, if a state expropriates, there may be that the state is not in a position to pay compensation at that particular time. Therefore, it is merely a legal consequence which comes later, at the later stage. The two requirements must be present at the time that the expropriation is carried out. However, compensation at times cannot be paid immediately at the passing of the law, or at the taking of the particular property, but can only be paid at the later stage.
We have gotten the gist of your argument, and I think time is running. You may wish to then give an opportunity to your co-agent, on whom I would call now. Thank you.
Your Excellency, is it my understanding that my time is out? Is my time out? I believe I still have 5.
Oh, I thought
I
you
bus-
had
I
this
believe I
stop
still have-
sign.
That was 10 minutes.
Oh, I'm sorry, I saw this stop sign. No, please, go ahead.
Yes, Your Excellency. In any event, Your Excellencies, we contend that the standard of compensation under international law has been complied with. So even if the court were to hold that that was a requirement for an expropriation to be lawful, the expropriation has been, the compensation as required by international law has been paid, and therefore it must be found that the expropriation was lawful. We contend that the standard of required under international law is not that of prompt, adequate, and effective compensation, but that found in Resolution 1803, which has been held by subsequent practice in arbitral tribunals, including Texaco versus Libya, to be the standard which international law requires. Appropriate compensation does not amount to full compensation at all times, but the concrete facts of each particular case must be taken, and then the standard of compensation must be decided upon. We contend that in the particular circumstances of this particular case, given the fact that the respondent is an LDC state and that the interests which were being expropriated were such of a wide nature, then it must be found that the book value method represents the appropriate standard of compensation as required by international law.
Judge Wilner has a question. Judge Wilner.
But counsel, you're just giving us a conclusion, the conclusion that you think is right, of course. But why is does this all come about?
Pardon, Your Excellency?
Everything you just said now, why is compensation sufficient? Why has in paying the book value in this particular case, your client's duties been fulfilled? What are your authorities for all of this?
Your Excellency, we contend that the standard of compensation required by international law is that of appropriate compensation. I mentioned my authority for that. It is that it's found in Resolution 1803, which enjoys the support of most of the states, including developing states, not merely developed states, as is in the case of the Hull formula. The applicants mentioned the bilateral investment treaties. However, Professor Shaw states that bilateral investment treaties may be reflective of state practice, but the missing element there is that of opinio juris, and therefore they do not constitute customary international law. With regard to the book value, Excellencies,
We hear from the other side of the bar that this standard of appropriate compensation has not been endorsed by developed countries. You would still argue that it is a norm of customary international law, even though it is embodied only in a resolution, be it denominated a declaration of the General Assembly, which incidentally is not binding.
Your Excellency, we contend that the standard set out in Resolution 1803 is that accepted by most states, including developed states and developing countries, whereas the one which the applicants mentioned is not accepted by developing states. We must take the one that is most accepted by all the countries in the world, and not merely the one that is taken by developed states, because that would amount to saying that law only develops if the developed states agree to that particular law. Your Excellencies, I see that I do not have much time to deal with the issue of national treatment, and I would therefore like to move on to that particular issue. We contend that the rule of national treatment as found in GATT Article 3 is not a rule of customary international law. We may accept that it is non-creating. We may accept that there is state practice. However, important requirement of opinio juris has not been met. Those states who are parties to the GATT act in accordance with that particular rules because it is their contractual obligations according to the rule of pacta sunt servanda, Your Excellencies.
Judge Richstone.
What do you say, Agent, to the argument raised by Agent for Bretoria that there were states that were outside of the GATT that accorded national treatment in the absence of being a member of GATT?
Indeed, there are such states, Your Excellencies, but the North Sea Continental Shelf case, which was decided by this court, stated that when we are to deduce national treatment, the applicants bear the burden of to prove that those states who are not in the treaties have acted in accordance with such a rule with an intention of being bound by a rule of law, but by feeling that they have a legal obligation. Applicants have produced no such evidence. For all we know, those states could have been acting out of their economic interests for moral reasons, whatever they may be. However, no evidence has been led to show that they were acting in accordance with a legal obligation, and that is what the North Sea Continental Shelf case stated. Those states who are outside the party but act in accordance with a particular rule must act with a conscience of being bound by a legal obligation, not merely out of any other political consideration, economic consideration, but by a feeling of being bound by a legal obligation. Therefore, if the court finds that this particular requirement has not been met, the rule in question, that of national treatment, cannot be said to have become a rule of customary international law, and consequently, the minimum content requirements passed by the Republic of Pagonia fall within the exclusive jurisdiction of that particular state to do as it wish, and also relating to the bilingual requirements for periodicals also fall within the sovereign jurisdiction of the state to legislate as it pleases, and therefore no international wrong has been committed by the passing of those two above mentioned rules. If, however, the court reaches the opposite conclusion, that the rule of national treatment has become a rule of customary international law, we contend that there is an exception allowed in order to protect cultural identity. Numerous treaties, like the Canada Free Trade Agreement and the North American Free Trade Agreement, have a cultural exception in those particular agreements. And also the European states impose quotas to protect their own cultural identity on television works produced on TV during prime listening time. Therefore, Your Excellencies, it must be found that, I believe Your Excellency has a question.
Please finish your...
It must be found, Your Excellencies, that there is a rule under international law that allows states to take a cultural exception. Those are not the only states. There are other states, including South Africa, which also has that particular rule, which allows for minimum content for television and radio, Your Excellencies. Therefore, a cultural exception must be found to exist.
My question to you, Agent, is this: that in every one of these instances that you mentioned, the cultural exemption that you cite are very particular to that country and to the particular nature of the exception. It can deal with broadcasting, it can deal with periodicals, it can deal with different kind of cultural industries. How can you say that all these very specific exceptions that you find throughout the legislation in the world creates a norm of customary international law?
Your Excellency, perhaps I didn't spell this out quite clearly. However, we do not contend that it has become customary international law, but that it is merely an exception which states under treaty, under bilateral treaty agreements, under multi-trade agreements are allowed to take to the particular rule of national treatment.
That's an exception because of a treaty, not because of any other practice.
Your Excellency, if the rule of national treatment has become customary international law, then all the exceptions which are found to that particular rule in trade agreements must be taken with that particular rule when applying it at customary level, Your Excellencies.
Thank you, Agent. I think this time I'm seeing right. Your time is up, and I would call on your co-agent to address the court. You have the floor.
Pleases the court. As my co-agent already stated, my name is Lungo Matakala, appearing on behalf of the respondent. And as he already stated, I will be addressing the issue of copyright infringement, and I wish to take up 20 minutes of your time. Having heard the argument put across by the applicant pertaining to the issue of copyright infringement, we have 3 submissions to make. The first submission contains our main argument, which is that Pagonia has no obligation to provide protection for intellectual property rights of non-nationals. This is because such an obligation can only arise from treaty or customary rule. Pagonia has not signed any such treaties, and we contend that protection of intellectual property rights of non-nationals has not evolved into a rule of customary international law.
Be more precise. When you say protection of intellectual property of non-nationals in the territory of your own country or abroad?
In the territory of our own country, Your Excellencies. The matter that is before the court that the applicant is contending is that Pagonia has not afforded sufficient protection to the copyright holders, the Bretorian copyright holders in Pagonia, and we contend that Pagonia has no obligation to provide such protection. The second submission that we have to make contains our alternative arguments. The first alternative argument is that should the court find that somehow mysteriously the protection of intellectual property rights of non-nationals has evolved into a rule of customary international law, Pagonia is a persistent objector to such a rule and as such is not bound by that rule. Our second alternative argument, should the court find against the first alternative, is that Pagonia is a less developed country and should therefore be given a grace period before she can be expected to implement the minimum standards of protection for intellectual property rights of non-nationals. Our third submission contains our prayers, which is that this honorable court should find that 1, Pagonia is not obliged to provide protection for intellectual property rights of non-nationals, and as such, 2, Pagonia is not liable to pay compensation to the Bretorian copyright holders who have allegedly suffered copyright infringement in Pagonia. I'll now move on to the substantive aspect of my argument. Your Excellency, Pagonia has no obligation to provide protection for intellectual property rights of non-nationals. Such an obligation can only arise either from a treaty or from a rule of customary international law. I will start by the treaty. Your Excellency, Pagonia has not ratified the Berne Convention. Pagonia has not ratified the TRIPS Agreement, the Universal Copyright Convention. Pagonia is not a member of the WIPO, nor the WTO. In short, Your Excellency, Pagonia has no obligation to provide protection under treaty law. As the Vienna Convention in Article 34 states.
I would like to ask a question. Your Richstone, please.
I'd just like to get to the point, to the gist of your argument. Are you suggesting that a country can accept copyright works of another country, allow that to be disseminated, distributed in the country, allow that to be exploited, allow that to be copied, that a country can encourage investment by another foreign country and can at one point in time say, I refuse to provide any protection? Is that what you're suggesting?
Your Excellency, in order for a state that exports intellectual property, if such a state wants its intellectual property to be protected, the onus is on such a state to see to it that a country that it exports its intellectual property into does provide for such protection. The onus does not lie on the state which is on the receiving end of such protection.
Didn't the country encourage and accept the introduction of the Pretoria's copyright works in its country for many years?
Your Excellency, indeed, after Pagonia became a democratic nation, a lot of foreign investment came into the state. But we contend that less developed countries do not benefit from foreign investment. And for this reason, Pagonia, being a persistent objector to the protection of intellectual property rights of non-nationals, does not wish to protect the intellectual property rights of non-nationals.
Judge Wilner would like to ask a question. Judge Wilner.
From what you keep repeating, Counsel, you don't want to protect copyrights of foreigners, and by implication, you have no problem in protecting the copyrights of nationals. Does this mean that the policy is to encourage copyright protection for nationals, but not for non-nationals?
Your Excellency, in the United Nations Charter, Article 2.1 provides for state sovereignty. Article 2.7 provides that states have the right to pass legislation, provides that states have got the right to domestic jurisdiction, and this implies, Your Excellency, that a state has the right to administer its domestic affairs. We contend that protecting intellectual property of our nationals is a matter that falls within domestic affairs. If we should contend that protection of intellectual property rights of non-nationals is a domestic affair, we disagree with that, because such protection, as I have already stated, only comes if the state has ratified such a treaty that provides for that, or if such protection has evolved into rule of customary international law.
Therefore, Counsel, the state can discriminate against non-nationals.
I would, to clarify my previous question, because it is in the same sense, if the holder of a copyright who happens to be a foreigner would try to get copyright protection in your country, the fact that he was a foreigner would make him ineligible for such protection. That was the gist of my question, and is that what you are arguing?
If Your Excellency would repeat
It's
his
in the same
question?
sense as the question of Judge Wilner. He has asked if, in effect, you are discriminating against foreign holders of copyright.
Yes, Your Excellency, we are discriminating for the simple reason that we do not have the obligation to provide protection for intellectual property rights of non-nationals. The protection of intellectual property rights of non-nationals has not evolved into a rule of customary international law. Indeed, as the other speakers that came before me have already stated, there are two general principles that must be met, two general requirements, that must be met before a practice can evolve into a rule of customary international law. These are state practice and opinio juris. Indeed, Your Excellencies, agents on behalf of the applicants have cited how many states have ratified the Berne Convention, the TRIPS agreements, etc., and those states provide protection for such intellectual property rights. And indeed, they cite that by virtue of having so many states providing such protection, that meets the requirement of state practice. Your Excellencies, we do not agree with that. Your Excellencies, that is tantamount to saying that by virtue of having multilateral treaties that have been ratified by so many countries, that multilateral treaty can be equated to a rule of customary international law.
And the natural consequence of your argument would be, of course, based on principles like sovereign equality or reciprocity, that foreign states would be also entitled to behave in the same manner towards your nationals who are holders of your own copyright.
Your Excellencies, we have not entered into any agreements with any states that provide that such states should protect intellectual property of our nationals. Therefore, if such states do not provide such protection, we will not contend that such states must provide for such protection. Your Excellency, the second requirement that must be met before a practice can attain the status of customary international law is that of opinio juris, as was stated in the North Sea Continental Shelf case. And indeed it is stated that in order for the requirement of opinio juris to be met, states must act with the obligation of feeling bound by a rule that exists, the belief that there is a certain rule that exists and that they are bound by such a rule. We contend, Your Excellencies, that states that provide protection for intellectual property rights do so merely because they have ratified treaties that provide for such protection. We contend, Your Excellencies, there are numerous states out there that do not provide for such protection. Therefore, this shows, Your Excellencies, that such states do not feel bound to provide such protection. And indeed, even among the states that have ratified the treaties, there are states that still do not provide such protection, that still do not abide by the rule to provide such protection. This shows inconsistency as well as non-uniformity as far as protection of intellectual property rights are concerned. This, therefore, leads to the finding that the protection of intellectual property rights of non-nationals has not evolved into a rule of customary international law. If, however, the court finds that somehow mysteriously the protection of intellectual property rights of non-nationals has evolved into a rule of customary international law, we contend as our first alternative argument that Pagonia is a persistent objector. According to Brownie, Your Excellencies, a state that shows its initial descent from the very beginning that a rule is evolving is a persistent objector. An analogy can be drawn here, Your Excellencies, to a club that has got members, and members that are bound by norms of that club. And Pagonia can be seen as a little boy that is outside that club and is not willing to join that club, is not willing to be bound by the norms of such a club. As such, Pagonia meets the requirement of a persistent objector. Time and time again, treaties have been ratified, organizations have been formed, many states have joined this, many states have ratified this. Pagonia has chosen not to.
If I may interrupt, and I would remind the participants that states that appear before this court are equal, so you should not consider yourself in the position of a little boy appearing even for purposes of that example. Josh Richstone has a question for you.
Agent, I have difficulty following your argument. It's one thing to say that there are a number of international treaties and multilateral agreements and bilateral agreements signed, but I don't see anything in the facts. Perhaps you can point them out to me to suggest that your country is a persistent objector. It may have objected at the end, it may have made some kind of representations at the end, but I don't see anything in the facts, and perhaps you can point it out to this court, how persistent. I don't see the persistentness of, or the persistency in your objections.
Your Excellency, it is stipulated in the very facts that in the past 4 years, the 3 functioning regions that Pagonia has which prosecute alleged copyright infringements have each prosecuted 150 people in the past 4 years. This brings the total number to 1,800 prosecutions. Not even one of those, Your Excellencies, was a prosecution against a copyright infringer who has violated a Bretorian copyright. This shows, Your Excellency, that Pagonia discriminates in its prosecutions. Not even random selection would have it that 1,800 prosecutions could lead to.
I'm sorry to interrupt. I fail to see how the fact of prosecutorial discretion in a number of cases leads to the status of a persistent objector in international law. Perhaps you can. It seems to me that they're operating at different levels. You're talking about an individual, a prosecutor in a certain district deciding whether or not to prosecute, and you're telling me that that amounts to a persistent objector in international law?
No, Your Excellency. What leads it to being a persistent objector, as I have stated already, is the very principle stated by Brownie, initial descent as far as the evolution of a particular norm is concerned. By virtue of Pagonia not ratifying any treaties and joining any organizations, Pagonia is showing its descent from providing protection for such. And this is evidenced. It's simply clarified through the prosecutions that I have cited to you, Your Excellency.
So you're suggesting that any state that does not ratify an international convention at the time that it is entered into is dissenting from it? Is
Your
that what you're
Excellency,
suggesting?
that is what is stipulated. That is what is stated by authors in international law, such as Brownie.
Fine. We'll exceptionally give Josh Wilner the opportunity to ask a question, and you should give a brief reply, please.
I'm intrigued by the fact that my colleague, my greatly esteemed colleague, in fact, has asked what persistent, the status of persistent objector is, and your response has been that in one or another, that your client has not entered into one or another treaty. What is it about the word persistent? Is it once, twice, 3 times? How many times?
Your Excellency, I had drawn an analogy to a club in which a club that has got members and it's got norms. What more would be expected of this little boy? Every day to knock on the door of that club and say, hello, I'm not playing, I'm not bound by the rules. No, Your Excellency, by virtue of this little boy remaining outside the club and not abiding by any norms that bind the members of such a club, this state shows, or this boy, which I am referring to as Pagonia, shows its initial descent as well as its continual descent. Your Excellency, there are no rules in international law which state that in order for a state to be considered as a persistent objector, it must hold a press conference or something like that every year. By virtue of it showing its initial descent and by virtue of it taking a positive act that shows this descent, such a state can be considered a persistent objector.
Thank you very much, the co-agent of Pagonia.
Thank you for your time, Your Excellency.
This concludes the first round of argument, and we would entertain now a second round of argument. We would first give the floor to the Republic of Bretoria. You have the floor.
Your Excellencies, I will be taking 3 minutes of this court's time in the rebuttal. Firstly, Your Excellencies, dealing with expropriation and the need for public purpose, this very honorable court in Electronica Secula in 1989 clearly held that non-discrimination is an essential requirement for expropriation to be lawful. Moreover, Article 9 of the Charter of the Rights of Aliens of 1985 clearly states that any discrimination against non-citizens in matters of expropriation would render the expropriatory action to be unlawful under international law. Your Excellencies, on the grounds of compensation and the payment of book value, 4 arbitral tribunals have expressly rejected book value. I'm referring to the American International Group case of 1983, which the Kingdom of Pagonia relied upon. I'm relying upon Aminoil arbitration case, the SETCO arbitral case, and the AMOCO arbitral award, all of which expressly rejected book value as a form of valuation in the cases of expropriation. Moreover, Your Excellencies, it is important to note that book value, Your Excellencies, does not include the intangible assets of a corporation, such as goodwill, future prospects, and patents, and therefore can never, ever constitute full compensation. Your Excellencies, on the point of copyright protection, Article 27 of the Universal Declaration of Human Rights declares copyright as a human right, a point which the Kingdom of Pagonia has not rebutted. As held by the United States Second Circuit of Court of Appeals in the Philartiga case, the UDHR is representative of customary international law. This point has also been accepted by this honorable court in the Western Sahara cases. Further, Your Excellencies, as point of state sovereignty and whether the Kingdom of Pagonia can discriminate between Pagonians and non-Pagonians in the protection of copyright, Your Excellencies, it is a well-accepted principle of international law that state sovereignty is subject to international obligations, as pointed out by the predecessor court in the Lotus case. Your Excellencies, therefore, since copyright is an international human right and is universal in nature, the Kingdom of Pagonia's sovereignty to afford copyright protection is subject to such obligations, and therefore copyright protection has to be provided. With that, Your Excellencies, the Kingdom of Pagonia, the Republic of Bretoria rests its case.
I thank the agent of the Republic of Bretoria, and in the second round in our court is the round for rebuttal. I give now the floor to the agent of the Kingdom of Pagonia.
Thank you, Your Excellencies. I will rebut the issue raised by the applicant with respect to the protection of copyright. Yes, Article 27 of the Universal Declaration allows such a right to moral and material interests. However, not all the provisions of the Universal Declaration of Human Rights have become customary international law. That is the first contention we make. Numerous authors, we would contend that the provisions of the Universal Declaration which have become customary international law are the core principles of those of civil and political rights and not economic rights. Therefore, in the first instance, the protection in Article 27(2) is not a rule of customary international law. Therefore, no obligation arises for the state of Pagonia.
Wouldn't you say, agent, wouldn't you say that the right of an author certain rights of an author, such as moral rights, could be considered to be not an economic right, but a human right?
It is a human right as stipulated in the Universal Declaration, Your Excellency.
What do you say then about your regulations which force copyright owners to translate their works in your language? Is that not forcing them to exercise their rights in a way that they may not have chosen freely? And wouldn't that be against their moral rights and the rights laid down in the Berne Convention, which set out that the author is has the exclusive authority whether or not to use and exploit his or her work in the way he or she wants?
As I state,
And to associate his or her name with that work?
Your Excellency, I contend that it is not custom. If, however, it is custom, the rights in the Universal Declaration are not unfettered. They are limited. We contend that in this particular case, it is limited in order to protect the rights of other people within the state of Pagonia, i.e. their right to enjoy their own language, to have access to information in their own particular language. Therefore, that must exist as a limitation to the particular rights which the applicants have relied on.
If you feel you will need 1 more minute to round up your rebuttal, I will be willing to grant it to you.
Your Excellency, that is a rebuttal I wish to make. I have made the 2 points which I wanted to make in my rebuttal. Thank you for your time, Your Excellency.
Thank you very much. I want to thank the agents, co-agents, and silent counsel of the 2 states, the Republic of Bretoria and the Kingdom of Pagonia. The court will now retire to deliberate. I would ask the representatives of the 2 states to remain at the disposal of the court. We will return in due course, and until then the meeting is suspended. Please be seated. The court is in session. It is my pleasant task to announce the results of this competition. I will do so in a few moments. But before, I would like to express on my own behalf and on behalf of my 2 colleagues in the bench our great appreciation for having been given this opportunity to judge the final of the 40th anniversary competition. It has been indeed for all of us here in the bench a unique experience. We have had in our own capacities experience in the past with moot court competitions. I have not participated in the present, at least this year. My 2 colleagues had been involved in one way or the other at previous stages. I did have the honor to judge the final of the Jessup on the occasion of the 50th anniversary of the United Nations in New York. And often judged the Telders competition is an offspring of the Jessup in Europe. And I can sincerely say that this has been, for me and for my two colleagues, the most remarkable final we have ever been involved in. It is, of course, a source of gratification for the two finalists to have reached this moment after very arduous international rounds involving as many as 62 teams and representing at least 50 different countries. So already the fact that you are here is in itself a source of great distinction. As in many other competitions, what counts, of course, is to participate, perhaps not to win always, but it's nice to win. And I think in some measure, the fact that you are both here shows that you both are winners. We have been very impressed by the way in which you have presented your arguments. We did not have the benefit of reading your written memorials, so we have judged you exclusively on your oral presentations today. But given the constraints of time and the fact that the bench was rather active in asking questions from both sides, you did manage to complete your presentations in a coherent manner, in a way that enabled us to see how rounded your arguments were. You were quick to respond to questions, were not put off by questions. Were ready to answer and give all the necessary argument in support. And given the fact that perhaps you had to argue a position that was not necessarily the strongest, as opposed to what you might have done in the written pleadings, you presented the best case that could be presented for each side. And I'm referring to both because this is the impression we have had from both of you. And of course, this would have led us to score you evenly had we had the opportunity to do so. However, we have to choose a winner, and we have done so unanimously. But the difference between the winner and the second winner, not a loser, is minimal. I will ask my colleagues to accompany me now down to the lectern from where I will announce the runner-up and the winner and present them with their trophies. I can assure you that not last-minute pressure is being put on us to change our verdict. We have been asked to first of all, choose the best oralist at this final session. And there again, unanimously, we have chosen Mr. Lawrence Mashaba. The runner-up is the team representing the Kingdom of Pagonia. Composed of Ms. Lunguwe Matakala and Mr. Lawrence Mashava, and the coach, Mr. Frans Wilkoen. Or, I'm sorry, my Dutch, even though I live in the Netherlands, seems to be a little rusty. And they represent, we have been told, the University of Pretoria in South Africa. It's with great pleasure that I give you this talk. And the winning team, no secret to anybody, of this 40th commemorative session of the Jessup competition is the team representing the Republic of Bretoria, Sapna Kajuria, Dipen Sabarwal, and Priya Pillai, whom come from the National Law School of India University in Bangalore. It is my Congratulations. 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 You will now be able to inscribe your names in this wonderful trophy. It's only left for me to thank again the organizers of the Jessup competition for this opportunity, and to hope that we will see each other perhaps again in the not too distant future. I declare the 40th commemorative session of the Jessup competition closed. Thank you.
Stand for a picture, we'd be very happy.
Yes?
With our photographer here.
Okay.